Since 2007, Mr. Culp and Mr. Conway have maintained a professional relationship. 50. On February 11, 2013, one of Mr. Culp's former clients filed a disciplinary complaint alleging Mr. Culp failed to file documentation that Mr. Culp represented had been filed. Mr. Culp acknowledged the substance of the complaint was true and reached a settlement with the State Bar of California in December 2014. 51. Sometime prior to November 3, 2017, the appellant retained Mr. Conway as lead counsel to represent him. Mr. Conway understood at all times the buck stopped with him. 52. In 2018, Mr. Culp was taking medication to manage depression, but in otherwise good health, having run a marathon in January and June. 53. In June 2018, Cap Berry was detailed to the appellant's case, his first general court-martial as a defense counsel. Cap Berry was not privy to all strategic planning communications during trial preparation, and his work predominantly focused on presentencing matters. Cap Berry's work on the case was all pre-proved by Mr. Conway and/or Mr. Culp. 54. Around 5 weeks prior to November 27, 2018, Mr. Conway discussed with Mr. Culp the possibility of assisting with the appellant's upcoming court-martial. 55. Around 3 weeks prior to November 27, 2018, the appellant retained Mr. Culp as second chair. Mr. Culp arrived within days of being retained, and lived with the appellant in the weeks before trial preparing the case and his cross-examination of Casey. 56. Mr. Culp believed he could file a continuance if one was needed. He did not need additional time. He also did not believe a continuance would be beneficial to the appellant. There was unspecified evidentiary concerns that made a sooner vs. later trial date beneficial to the appellant. 57. Mr. Culp did not believe there was value in presenting the appellant's PTSD and findings, only sentencing. Due to his 18 years of experience, he had experience in other cases with more significant grief PTSD that did not obviate a finding of guilt. Additionally, he did not want to open the door to evidence the appellant was responsible for his Fiang Case 13 death. 58. Mr. Culp was prepared to use specific segments of Casey's law enforcement video interview during cross-examination. He had time segments noted, and a written transcript of the interview prepared. Hard drive knowledge and use. A. The appellant procured a digital extraction of 1 or 2 hard drives on his own initiative. B. Mr. Conway made a backup copy of the digital extraction, described as 2 folders or 2 hard drives or a thumb drive. He maintained possession of the copy at the time of the Dubé hearing. 1 folder or hard drive contained Casey's personal 13. Mr. Culp stated first wife. The record of trial indicated the appellant's first wife lived and his fiancé died.